Good morning. It is very polleny out here today, so if I sneeze or rub my nose, it's not from the cocaine. I assure you, it's allergies, not cocaine. Trust me. All right, so today we are going to go over some filings from Decastro versus Abrams, and we're going to go over some filings from Wagner. And before I jump into it, in Chili's motion, or in his lawsuit in Las Vegas, there was a beautiful 12b6 motion filed. It was lovely. It was gorgeous. Well written. I actually looked up the attorney who wrote it, and he's only been practicing since 2021. So I'm shocked that it was that good, but it's probably a very reputable firm. I don't know. But it was an excellent, amazing 12b6 motion to dismiss, and it's absolutely meaningless because all Chili's going to do is he's going to amend his complaint into a first amended complaint, thus making the 12b6 motion useless and moot, and who knows what Chili's going to do. I mean, Chili might turn the whole thing into a copy. Seriously, this is the first time you start crowing, huh? You wait for me to sit down and turn this on, you little asshole. So he might turn it into a copyright claim or something. I don't know. Anyway, so we're not going to go into that. We're going to wait for something substantive to come out of it. And instead, we're going to jump into this is Abrams. This is Chili's opposition to Google's motion to transfer, or in the alternative, to dismiss. Points and authorities. So we're going to look for points and we're going to look for authorities in here. I have not read this. It's funny, the one that I did read, we're not covering today, but I read it because we're not covering it. So every goddamn time. They literally come over to where I'm at. Hi, buddy. They literally come over to where I'm at as soon as I sit down here. So, A, plaintiff did not agree to sue in the Northern District of California. This is the classic Chili nope defense. YouTube has clearly not yet read the first amended complaint and the first and second supplemental complaints brought by plaintiff in this action. This action is not regarding any agreement between plaintiff and YouTube. I believe that the terms of service mean that anything that comes out of his relationship, Chili's relationship with Google, is getting resolved in, or his use of YouTube's platform means it gets brought to Northern California. So I'm going to go with you did, Chili. You just don't understand it. Plaintiff has brought this copyright infringement in action against YouTube users that are committing wholesale copyright infringement of plaintiff's creative works. Well, if you say it repeatedly, then that will make it true. YouTube has been joined, as it is at least partially liable for its failures to abide by the DMCA. In violating the DMCA, YouTube's lost any safe harbor provisions it would normally have under the Community or Communications Decency Act. Although YouTube interprets our terms of service between plaintiff as the plaintiff promises to pursue all federal litigation regarding the service exclusively in the Northern District of California, the actual terms say otherwise. The TOS defines service as the products, services, and features we make available to you as part of the platform. The TOS then goes on to say all claims arising out of, or relating to these terms or the service will be governed by California law, except California's conflict of laws rules, and will be litigated exclusively in the federal or state courts of Santa Clara County, California, USA. You and YouTube consent to personal jurisdiction in those courts. Now, I don't know if anybody else read all of the appendices of links to videos that Chili claims were copyrighted, every single one of those was a YouTube link. Every last freaking one of them. How is this not related to the terms or the service? The terms of the TOS or the service? How is it not? If it is literally linking to a YouTube video, how is it not related to the YouTube service? I guess we'll have to let Chili make it clear to us how it doesn't relate to the YouTube service. This makes it clear. What makes it clear? Okay, this makes it clear the forum selection clause in the TOS and the TOS itself only apply to claims between users of the service and YouTube related to the products and services that YouTube provides the users, not all claims related to YouTube. So Chili is correct. Like if there is a third party company that provides, I don't know, web hosting or something, server rack space for YouTube, and they want to sue YouTube, they're not bound by the terms of service. They would be bound by whatever contractual arrangement they have, if any. If not, then they'd be bound by the normal rules for venue and jurisdiction. But this is a claim between users of the service and YouTube, because Chili is a user of the service and YouTube, and is related to the products and services that YouTube provides the user. I don't know what the hell he's trying to say. YouTube's wild interpretation would require anyone that's ever watched a YouTube video to be bound to bring all claims against YouTube in accordance with the forum selection clause in the TOS, regardless of whether the claim arose out of to its service. Okay, going back to my previous analogy, a third party that's providing server use for YouTube's services, if they happen to watch a YouTube video, that doesn't mean that all of a sudden they have to bring a breach of contract for the server contract according to the terms of service. They could bring it according to the contract between them and YouTube for the servers. Or if there's no forum selection clause in that contract, then they could bring it just anywhere according. Well, it would probably be in the Northern District of California, because that's where YouTube's located. But you get my point. Like, just because you watch a video, true, that doesn't mean that all claims against YouTube are. But we're not talking about all claims. We're talking about specifically Chili's claims, and Chili's claims are specifically a claim between a user of the service, that would be Chili, and YouTube, and it's related to the products and services, i.e., the list of YouTube videos that Chili claims are copyrighted and whose copyrights Chili claims are infringed, that YouTube provided to Chili. I don't know what I'm missing. YouTube then cites many cases related to parties suing YouTube for the services it provides, which are irrelevant here. The instant action is actually like Viacom International versus YouTube, where Viacom, oh, Jesus Christ. Well, let's look it up. I have not read this. I was not aware that it would be a Viacom, which might be providing some sort of a web service for. It's a case brief. Here we go. Is it for law students? Here's casetext.com. All right. All right. So Viacom was not a user. In this particular case, Viacom would be the owners of the copyright. They were not putting it on YouTube. Viacom owns various production companies and things like that, various licenses to intellectual properties. So people were posting like Viacom movies and Viacom music on YouTube. Viacom was not the user. That's the difference. That was easy peasy lemon squeezy. I don't know why he had to go there. Where YouTube did not argue its TOS applied because Viacom was not a user. That's why. That's why it didn't apply. Chili is a user, Viacom not a user. That's the difference. Viacom's action was related to YouTube's failure to take appropriate action for copyright infringements on its platform, but Viacom was not a user. Viacom had arguably used YouTube in order to see that there were infringing content on the platform, but they did not upload it. The terms there is a difference. They found that their content was on YouTube, but they're not a user. They're not a user. You are a user. Chili, by uploading your videos, you have agreed to various things. By using the services of YouTube to host your content, you are a user. If someone, so you don't even have to have an account to view the videos. Generally speaking, you don't have to have an account to view the videos. I think some of them you have to have an account, like if they're naughty or if YouTube thinks they're naughty. Viacom had arguably used Viacom. So here's another thing. Viacom is a corporation. Viacom can't watch a video. Corporations can't watch a video. Agents for that corporation might watch the video. Sure. Employees of the corporation might watch the video, but the corporation can't watch the video. So, oopsie. But anyway, just watching a video doesn't make you a user, as in bound by the TOS. So, YouTube is not a necessary party in this action under Federal Rule Civil Procedure 19, and its forum selection clause would be unreasonable. I have no idea what we're doing here. So, well, let's look at FRCP 19 first. FRCP 19. Magic. Close that. Well, this is going slow. Are we going to do something? Can we? There we go. All right. Required joinder of parties. Persons required to be joined. So we're not trying to join anyone. So I don't know why we're talking about FRCP. Joinder, there's two kinds of joinder. There's permissive joinder and there's mandatory joinder. Permissive joinder, let's start with mandatory joinder. Mandatory joinder would be like if you're going to sue an insurance company for a payout that you think you're owed because of actions that one of their insured did, that insured would be a mandatory joinder. They would have to be joined as a defendant in that case because they're the ones who have the liability. I know that's a terrible example, but you get the idea. A mandatory joinder is where you actually absolutely need that person there as a party in order to be able to litigate the action. That's to join it. That's like, oh, hey, they filed this lawsuit against me, but I need to bring this other part. I have to bring this other party in. Or let's say, for example, you're suing an estate for or a trustee because they are going to give assets to a third party, and you're trying to stop them from giving those assets to the third party. And the estate says, well, I have to have this third party here because they have a legal right to it and they have to defend their legal right to it. That would be a required joinder. Permissive joinder would be something where it would really be super helpful if we could have this third party here to adjudicate this particular issue. But we're not doing a joinder. Google is already a defendant. They're not joined, they're sued. A defendant is a necessary party. You can't resolve your issues against that defendant without them being there. They have to be there. They're necessary. You can't sue someone if they're not there. We're not even talking about joinder. We're talking about literally they're there. They are a party to the lawsuit already. We're not adding anyone to the lawsuit. This is a defendant. You're saying that you have some sort of a claim against that defendant. They're already there. You can't get rid of them and then still go ahead and get a judgment against that defendant. It doesn't work that way. It's not joinder because they're already there and they're a defendant, so they're fucking necessary. All right. So then we're going to look at C. White Marine Inc. versus S&R Corporation. Can I actually go all the way down to there? I can. All right. So we're going to Google that. And we're going to, it did not match anything. It did not match anything. All right. All right. So this is not a published case, which is awesome. Unless I misclicked on the quotation here. Oh, it captured other things. All right. So copy, and then we're going to paste, and we need to get rid of the crap out of the middle. Haha. Uh-huh. There we go. All right. What were we looking at this for again? Forum selection clause in a contract. So the plaintiff claims that it's owed money for work. Defendant has moved to dismiss, arguing it's bound by contract to bring its claims against Contech in Ohio. The court concludes that this forum selection clause is enforceable. It's enforceable. So what are we here for? What are, 30 Mass L Rep 631. 30 Mass L Rep 631. 30 Mass L Rep 631. All right, so we're in the right spot. So the court allowed context motion to dismiss. What am I missing here? I don't see anything in here about FRCP. There is nothing in there about FRCP. All right. So, well, I guess we'll look at this one. We'll look at this one. All right. Sorry about that. Okay, so we were looking at Fred Lurie, FRC, Federal Rules of Civil Procedure. All right, 12B3. Defendants are not necessary parties. Okay, here we go. All right, what are we talking about here? Plaintiff argues that even if the court were to enforce the forum selection clause used against Global HK, the case still proceed the court against in this court against defendant Port of Miami. Plaintiff states all the actions of the defense are necessarily intertwined. This is a matter of relitigating the exact same facts in 3 different jurisdictions, including 2 foreign jurisdictions, where all parties would have to be hauled before each court because they're necessary parties. Oh, Jesus effing Christ. All right, so what Chile has done is Chile has made a fundamental error of reading. The plaintiffs in apparently this case, and let's see in the C. White and Marine case, I'll bet you I'll bet you this one. Let's see. Well, let's see. All right, control it. Fred. So the concerns of the plaintiffs in both cases were that it would split the action into multiple forums with, and each party is necessary. And the court in both the C. White Marine and in the Fred Lurie said that no, the other defendants aren't necessary. The other defendants, not the defendant who's seeking to move this out of the case, but the other defendants aren't necessary parties. You don't have to have all these people together in order to get a resolution in each specific case. They're severable. They're not mandatory. They're not mandatorily joined together in that action. So what Chile is arguing is that if Chile or if Google's defense, Chile's lawsuit against Google, is moved to the Northern District of California, what his argument is that, well, necessarily, I think is what he's trying to say, is that Kate and Josh are necessary parties to that, and so they would have to be joined there, or Google would have to be drawn back into Massachusetts, and so because they're necessary, it's, I think what he was trying to argue is they were necessary, not that they weren't necessary, and he just got it completely bass backwards. But that particular argument was made by the plaintiffs in Fred Lurie and C. White and Marine. And the court said in both of those cases that no, you could do the contract issue separately. And yes, it would mean that there's 2 somewhat related causes of action going on in 2 different courts, but that's fine. I mean, you signed that contract, you agreed to that contract, you contracted those terms, and so you're stuck with the results of those terms. So I think he probably should have read these cases a little bit better, and maybe understood them a little bit better, because they're actually the opposite of what he was arguing. So, whoops, I didn't mean to close all of those. So share screen. We're on, I think, this one. All right. So YouTube was joined. They weren't joined. They were named as a party. They were named as a party in plaintiff's supplemental complaint because in a related action occurring after plaintiff's first amended complaint, YouTube acted in violation of the DMCA, allowing its users to keep infringing content on its platform and accepting at least partial liability. Again, all this can be severed. Even if YouTube's TOS applied for a forum selection clause, and it does, YouTube was added later and is not a necessary party. By saying that they're not a necessary party, you're arguing exactly the opposite. So if they're not a necessary party, then there's no reason why the court can't split this into 2 actions and dismiss the YouTube one so that you could refile it in Northern California or otherwise transfer it to Northern California. A forum selection clause here only prevents a party from arguing against using that forum for its own convenience. Citation needed, sir. Here, plaintiff argues for the convenience of the necessary parties, namely Here, plaintiff argues for the convenience of the necessary parties, especially the named defendants, Catherine Peter and Joshua Abrams, who reside in or around Massachusetts. This is a new tactic that I've never seen before. It's where the plaintiff is arguing on behalf of the defendants. That's a novel approach, Chili, and I support it. I think you should do that more often. Additionally, this court doesn't allow for changes of heart. I don't think Google, he's trying to, well, stupidly, he's trying to throw a jab at the court, trying to say, well, I tried to move it to California and you said no. So you said it wasn't allowing for a change of heart. Well, Google didn't file a lawsuit in Massachusetts and then try to move to the Northern District of California. Google was named as a defendant. They didn't choose this forum. They're not having a change of heart. Why would you throw a jab at the judge who's going to decide your motion? Why would you do that? What kind of a fucking moron? It's like, this is the person who holds all the power in this. I'm just gonna taunt them and do my best to make them not like me, because that will guarantee me a more favorable outcome or something. I don't know. Circumstances have changed. YouTube cites these cases from 2013 and 1972, which goes on to explain the court drew the distinction between a situation in which a party is contemplating the alleged inconvenience at the time the agreement was negotiated, and a situation where the inconvenience is a result of circumstances which were not present at the negotiation stage. You know what? You know what is never present at the negotiation stage of the contract? The breach. The breach is always a change from what the parties contemplated when they were drafting the contract. You draft the contract expecting the other party to not breach it. So in every breach of contract case, there is always a breach of contract, a material change from the circumstances the parties were envisioning when they entered into the contract. You moron. You moron. The court looks at the intent of the parties at the time they entered the contract. A contract requires a meeting of the minds. That's language that is taught to you in law school. It requires a meeting of the minds, and the court goes out of its way to determine what the parties intended at the time they entered into the contract. Not later. Obviously now, Chile doesn't want the forum selection clause. But what fucking good is a contract if you could change your mind later? A contract is designed to bind you to it. That's the point of the contract. Not to let you change your mind later. Oh, circumstances have changed. Not knowing that YouTube would violate the DMCA and add itself to this action after it was filed would clearly apply. YouTube didn't add itself. You named them as a defendant. You named them. You served them. Am I taking crazy pills? I need to calm down. Oh my God. Oh my fucking God. Talk about blaming the victim. You sue them. You serve them. You require them to appear. And then you accuse them of adding themselves to the action? Holy fuck. Oh, it's too early in the morning for this. Oh, I have a busy day ahead of me, so I have to get it done early. But my God. Poor judge. Well, she might be laughing. I'm sorry. She might be used to this, or her law clerk might be laughing because it's kind of stupid. The burden is on YouTube for showing why there's good cause for the transfer. Yeah, they showed it. It's in the contract. You contracted for it. Done. Only when a forum selection clause is free from fraud, influence, or overweening bargaining power does the burden shift to the other party. So what Chili's saying is that YouTube has to prove that it's free from fraud, influence, or overweening bargaining power in order to shift any of the cause to Chili to show that it shouldn't be transferred. Right here is where a citation would be inserted. Right there, if he had one. He doesn't. Plaintiff does hereby declare that YouTube had the superior bargaining strength and the plaintiff only had the opportunity to adhere or reject the agreement. Okay. And we're going to a Eastern District of Pennsylvania decision. Let's do this. So BABN is in the business of producing lottery tickets. Okay. They hired Bruno as a pre-press technician. Okay. Bruno was promoted to a pre-press supervisor in San Antonio, Texas. He signed a confidentiality agreement. Okay. He would not interfere or you not engage in activities. So this is an employment contract case. Now, without even reading further, contracts restricting your right to engage in various trades for a specific period of time after your current job is terminated are looked upon with extreme scrutiny by courts, because you have a right to make money and do all these things. And so the court looks at various factors like the range. Like there's a difference between not being able to engage in a trade or practice within like 5 miles of where you were working as opposed to anywhere in the country. And so a court's much more likely to allow a restriction, a covenant not to compete for a small radius as opposed to wherever. The time frame is also something the court's going to look at. Like, oh, I'm going to covenant not to compete for 6 months. That's going to be looked at different than a covenant not to compete for 6 years. Because I mean, 6 months, okay, sure. There might be some money in there to compensate you for that 6 month window to help you to make sure that you can actually like live for 6 months, not engaging in your trade. But 6 years, really? And then another thing the court's going to look at is what kind of a job you're doing. If you're doing something where you have access to trade secrets, to if you have access to like lists of customers, things like that, the court's going to look at that differently than if you're like a forklift driver. So this is an employment contract with a covenant not to compete is going to be looked at entirely different than a term of service. So just I already know this is not going anywhere, so I'm not going to read the whole thing. This is a covenant not to compete. So that's what it is right there. And yes, the issue with something like this would be looked at differently than a user EULA, end user licensing agreement or whatever. So yeah, sorry. Additionally, even where not unconscionable, the significance of a form selection clause in a boilerplate agreement is greatly reduced. Okay, well, we'll see here. All right. Okay. So Visicorp moves to remand this action to a state court. Remand to a state court on the basis of alleged defects in the. So this is not dealing with a change of venue. A remand. So cases are removed from state court to federal court, and they can get remanded if there is like if there's no jurisdiction, if there's no federal jurisdiction, or if the federal jurisdiction is somehow weak and it would be better to have the case heard in a state court, the federal court can remand it back to state court. That's different than changing venue. So I don't know why we're talking about removing and remanding. This is not applicable. It's inapposite. Okay, forum selection clause. Massachusetts law and jurisdiction shall be governed and interpreted in accordance with the laws of Commonwealth of Massachusetts. Party agree that any dispute arising under this agreement should be resolved in the state or federal courts. Okay, plaintiff resists the instant motion on the grounds that Massachusetts law controls venue determination, and then Massachusetts does not enforce forum selection clauses. Okay, so he's saying that Massachusetts law, the plaintiff was saying Massachusetts doesn't enforce forum selection clauses. Interesting. In the event the Massachusetts courts would enforce the clause, plaintiff contends the defendants nonetheless carry the burden of proving transfer to that state is in the interest of justice and yada yada, and they fail to do so. The first and foremost question present is whether federal or state law controls venue. Under the Erie Doctrine, it is axiomatic that a federal court sitting in diversity shall apply the law of the forum state here, California. California's choice of law rules. I have mosquitoes buzzing me. This is a California case? Yeah, he's citing a California case. Okay. Under the scenario, if there is some dispute as to whether California's choice of law rules would probably defer to Massachusetts pursuant to the agreement's choice of law provision. Under the scenario, there is some dispute as to whether the clause is enforceable. Thus, employing federal law over state law respecting the enforceability of the clause may create an undesirable result under the outcome determinative test, at least insofar as venue is concerned. However, it'd be sheer speculation as to whether the final outcome of this action would differ if the action would be held in Massachusetts or California. Moreover, because Massachusetts law has been chosen to mediate the dispute, the substantive law result would be the same irrespective of the forum actually litigated. The court holds that federal law controls under these facts. With all deference to the interest of the state of Massachusetts, federal laws, federal courts prevail. Next question is whether the clause is enforceable. The benchmark is this. This is a Supreme Court case from 1972, where the court codified the prevailing view that the contractual venue selection provision clauses are prima facie valid. Prima facie means on its face. So, like the court, if all the defendant has to say is we have a forum selection clause, done. Then the burden shifts to the plaintiff to show that it's not valid. And so the plaintiff tried to confine it. However, the court is persuaded Bremen controls the situation. So the court here is going to probably kick it to conclusion. The action has been properly removed. Federal law controls. Forum selection clause contained in the 79 agreement is valid and enforceable. Pursuant to the agreement, the venue lies in Massachusetts. The case you cited, sir, F's you in the a-hole. Congratulations. The problem is that he's trying to make arguments from cases that don't support his conclusion. And so he's trying to nitpick little things out of them and make it work. And it's not going to work. Plaintiff has not made copyright pleading failures and should be allowed to amend its complaint. Oh, he sure has. He sure has. I don't think amending the complaint's going to fix it, though. Although a copyright claim can be dismissed for not having alleged copyrights have been registered in accordance with the statute, a copyright claim only requires two elements. One, ownership of valid copyright, and two, copying of a constituent element of the work that are original. Does it say that? Let's check it out. Load better. Held. Rural's white pages were not entitled to copyright. So the court here is saying they're not copyrightable. Copyrightable. So they're looking at whether you can protect them with a copyright. Do. See, they're still talking about copyrightable. Why facts are not copyrightable. Originality is a constitutional requirement. Copyrightable. So what's he arguing? He doesn't actually cite a page number, so I can't tell you. Well, what ownership of valid copyright? To establish infringement, two elements must be proven. Okay, but it doesn't say only two elements. To establish, you have to prove two elements, but that doesn't mean that those are the only two elements you have to prove. Here, YouTube has joined the party a bit late, and the other parties never raised the issue. Is that a laches defense? Is he trying to make a laches defense? Is he trying to make a laches defense? And I'm pretty sure the other parties raised the issue. I'm almost positive. Let's look, shall we? Decastro versus Abrams. Oh, we're sharing this tab instead. Oh, Jesus. Number 94 and 95. So 94 is Peter's motion. Okay, fair use. Okay. So Peter just argued fair use. Wow. Excellent work, Mr. Wish. And then 95. Abrams' attorney seemed a lot better, so we'll hope Abrams' attorney has. What? There's no 95. 96. Okay. All right. Allegations. Has failed to plead ownership interest to the works. If you could prove the original Ordinarily, ownership vests in the author if he can prove the work is original and he complied with statutory formalities. Indeed, an author can establish prima facie ownership of his works if he obtains a certificate of copyright registration. Save for registration, it is Decastro's burden to prove exclusive ownership of his works. He has not pled in the First Amendment or supplemental complaint that his works are registered. He has also failed to plead that he has exclusive rights to these materials. So they did not sleep on it. Thank God Garrick was there, because Wish is fucking useless. You go, Garrick. You're my boy. All right. And so the other parties did raise the issue. So that's an oopsie doodle. I knew someone had done it. I thought both did, but Wish never fails to disappoint me. Plaintiff does hereby declare that it has successfully and completely registered at least one key video in its complaint, and that the registration can be easily found by searching the public catalog at loc.gov. Well, here's the thing. It has to be on the complaint. This is a motion on the complaint. So the court might give you leave to amend your complaint, but I don't know that you can register something like 6 months or a year after you file a complaint and then have it be valid. That would be interesting to find out. C, plaintiff did not license its videos to YouTube for any use, except for the whole terms of service thing. Except for the whole terms of service thing. The key video in this litigation was never published on YouTube. What key video is that? What is the key video? It would be helpful if your complaint had stated what the key video was. But we don't know. We've got lists of videos on YouTube. But it's a long way to go from he did not license his videos to YouTube for any use to one video was never published on YouTube. So there's all these videos. One video is never published, and therefore it's not a TOS issue. No, if any one of those is part of this, then the TOS would apply. Also again, plaintiff's complaint is against YouTube allowing its users to infringe on plaintiff's content. The TOS does not allow for this, and clearly the related license only allows those users to play back or embed the content. So right here you're getting into the rest of the contract. Before the court can get into the rest of the contract and say, well, all this other stuff doesn't apply, the court's going to have to determine the foreign selection clause. That's first. Because if the court doesn't have jurisdiction under the forum selection clause, then the court has to kick it over to the correct court and let that other court determine it. Since both parties stipulated to join YouTube in this action due to YouTube's actions, since both parties, okay, first of all, there were 3, and then there was Google, so there's 4, stipulated to join. No, you name them in your complaint, you asshat. Fuck me. It would be surprising if YouTube's dismissal or transfer granted based on their weak and boilerplate arguments that are used every time someone sues them over their TOS. Used successfully every time. Successfully. The courts are like, you know what? It's a boilerplate argument, but they don't need to reinvent the wheel every time. They don't need to make a new and fresh argument every time. They have a contract. The contract is solid. They're being sued on the basis of the service that they've contracted with the user about. And so boom, all of a sudden, weak and boilerplate arguments. I'm sure it sounded good in his head. YouTube should be at least required to read the complaint and plead relevant arguments. No, that's the point of a 12b6, is it gets you around that, or a motion to dismiss. And actually, they read the complaint. That's how they know that it doesn't contain anything that would prevent them from doing the motion to transfer venue and or motion to dismiss. If YouTube is dismissed from this action, it will just add to the possibility for the remaining defendants to make third-party complaints against YouTube for being liable to those defendants for all or part of the plaintiff's claims against those defendants. If YouTube is dismissed from this action, it'll add to the party that third-party that the remaining defendants will join YouTube in. No, because Kate, Peter, and Josh Abrams are users, and the terms of service apply to them, and the forum selection clause applies to them. So if they try to join YouTube, it won't work. YouTube would not be a necessary party. Again, it wouldn't be necessary because they're just trying to get indemnification, I guess. I don't know how they would seek indemnification, but they'd have to. They would not be allowed to join YouTube. They'd have to sue them, and they would have to sue YouTube in the Northern District of California. So I don't understand that. It would actually be convenient for plaintiff to have this action transferred, but plaintiff certainly did not agree to a relevant forum selection clause that would require it. Well, if it would be convenient for Chile to transfer it, then you shouldn't argue against it, you idiot. Even if plaintiff did agree, exceptional circumstances exist that would make it unreasonable, especially for the other parties. Again, this whole altruism thing, you don't wear it well, Chile. You don't wear it well. And you saying to the court that it would be convenient for you to have it transferred is certainly something the court's going to be like, oh, well, if it would be convenient, there you go. You were dumb enough to put it into your pleading. I'll go ahead and make it happen for you. So that was Chile's opposition. Now, I did check the local rules, and here's the relevant local rules. And all other papers not indicated in B1 or 2, whether in the form of a reply brief or otherwise, may be submitted only with leave of court. So Google wants to reply, and so they have to get leave of the court. Now, as attorneys are so often desirous of doing, they still make their argument. I did glance at this. It's very short, and I do love a well-written pleading. So Google moves the court pursuant to local rule 7.1b3 for leave to file a reply in further support of its motion to transfer or dismiss. So the way it goes is there's the motion, there's the opposition to the motion, and then there's a reply. I think in Ohio they call it motion response reply. Kind of weird, but okay. It's a local variation. So the moving party files the motion, the opposition party files the opposition, and then the moving party generally gets, usually not in Massachusetts apparently, an opportunity to respond to the non-moving party's arguments. Usually it doesn't go beyond that. Sometimes a party will move the court to file what's called a SUR reply, SUR, SUR reply. And then there's like a SUR reply, and it can get stupid. Usually the courts don't want that much paperwork. That's what oral arguments are for. If the court wants to hear more argument, they can invite oral arguments. If allowed, to reply be no more than 5 pages, it would be submitted on June 13th or within 10 days of the court's order, whichever is later. Most of the arguments in plaintiff's opposition brief require little response as their defects are readily apparent. See the opposition. But at least 2 of plaintiff's arguments are worth addressing in a short reply. First, plaintiff tries to remedy his failure to allege copyright registration before filing suit as required by 17 U.S.C. 411A by introducing the unpled allegation that he, quote, registered at least one key video in his complaint. If allowed, Google will explain on a reply that even if plaintiff could amend his first amended complaint to allege that one of his hundreds of supposedly infringed works is registered, this could not satisfy the pre-registration requirement. Google would provide a short declaration to the effect that plaintiff is evidently referring to, quote, my wrongful arrest, end quote, with a registration number, a video registered after plaintiff brought this action. Belated registration of one work after filing suit does not satisfy section 411A. See Cortez Ramos v. Martin Morales, etc. So what they're doing here is, and they're asking the court to allow them to file the reply, they're actually giving the core of their argument that they would make in the reply, thus really negating the need to file the reply. and getting the relevant law in front of the court without technically getting the relevant law in front of the court. The games we play. Second, plaintiff claims he did not license his videos to YouTube and asserts that the, quote, key video in this litigation was never published on YouTube, end quote. If laud, Google will demonstrate on reply that this assertion contradicts plaintiff's own allegations. See first amended complaint, paragraphs 4 and 13 through 19. And supplemental complaint at paragraphs 9 to 10. Further, plaintiff trains his argument on a different license than the one relied upon by Google in its motion. Compare motion at 5, quoting the license to YouTube in Exhibit A at 8, with opposition 4, quoting the license to other users in Exhibit A at 9. Google therefore requests the opportunity to address plaintiff's arguments, but they have already done so, and effectively, I might add. That ends the tale of YouTube versus, technically it's Decastro versus YouTube. Now we're moving on to Decastro versus Wagner. Chile has filed not one, but two replies. Instead of replying to the oppositions in one reply, he's made 2 replies, 1 reply to each opposition. Why you would do that? Well, it's probably because you're retarded. No offense to retarded people out there who Chile is giving a bad name by also being retarded. So he offers this. All defendants have sent interrogatories and requests for admission to plaintiff. He's responding on this one to Ironton's, the city of Ironton. Now, if I remember correctly, the city of Ironton is the party that he did not show. I think he did not show that. I think one of them he showed the one that withdrew their discovery. He showed their discovery requests, and the one that did not withdraw their discovery requests, he did not show their discovery requests. But at the end of this, the big question is: did he comply with the court's order? That's the big deal. The court has a specific standing order about discovery issues. Did he comply with that? If he complied with that, he would also have, by default, complied with a local rule. But courts get really kind of picky about their orders being followed. So we'll see. All defendants have sent interrogatories and requests for admission to plaintiff prior to the 26F meeting. This violation is good cause for the granting of a protective order. I don't think so. I think it's good cause for ordering that Chile not have to respond until a certain period of time after the 26F meeting is held, but I don't think it's a good cause for protective order, because theoretically, if Chile got a protective order, he wouldn't have to answer those discovery requests, theoretically, and that's unless the court very carefully worded it. So I don't think he's going to get a protective order. Points and authorities. Again, we're looking for authorities. He was so good with authorities on his last opposition that we'll see how good he is on this reply. And yes, Ohio does allow you to file a reply without leave of the court. Plaintiff is willing to participate in this action. Defendants make vague and conclusory statements about plaintiff's unwillingness to participate in this action and game playing. Well, just the mere fact that he filed this particular, let's do this. He filed this reply within a matter of days after, within 5 days. There we go. Within 5 days, they filed their responses on the 22nd and the 25th. By the 30th, he had replies done. So when their point was that when it serves him, he is Johnny on the spot. He's Johnny on the spot to get his stuff done. But to reply to their stuff, he waits till the very last minute. And he's showing, he is proving their case here. In being Johnny on the spot, he's proving the case. It is the defendants that have violated the federal rules of civil procedure that matter. Additionally, defendants have no control over the pending dispositive motions. Interesting. Scheduling a Rule 26F meeting prior to the pending motions being resolved would be wasteful. Well, no, it wouldn't. You need that Rule 26F motion. let me rephrase this. Assuming that the court does not grant the summary judgment and the 12b6 motion to dismiss that the defendants have filed, assuming the court does not grant one or both of those, and or grants Chili another bite at the apple to amend his complaint, then we will need discovery. Discovery is going to happen. And so having the 26F meeting sooner rather than later would be awesome. Now, if the court grants those motions for summary judgment and motions to dismiss, then it'd be a waste. But they want to get this done, and you'd think the plaintiff would want to get this done, but the plaintiff seems to want to drag his feet. Why would Chili want to drag his feet? Well, it's because he doesn't know what the fuck he's doing. And he's got a lot of work ahead of him on these discovery requests. Scheduling a 26F meeting prior to the pending motions being resolved would be wasteful. No, it wouldn't. Comparing plaintiff's communications issues with this court to defendant's actions to move discovery ahead prior to Rule 26F meeting and prior to the dispositive motions being decided, defendant's action seems like a stronger example of game playing or of sheer incompetence. No, they are moving this action towards its inevitable conclusion. The court doesn't want to be playing discovery games. The court wants you to get this shit done, get this matter set for trial, and get it out of the court's hair. That's what the court wants. Additionally, plaintiff has actively participated in improving communications issues with court by joining the electronic filing system at his own initiative. Plaintiffs declare surprise as to why they're suddenly getting responses from plaintiff through email as if they didn't see the motion for permission to file electronically. He could always have sent stuff through email. He didn't have to put his foot down on mail. Plaintiff's allegations were specific. Oh, and by the way, why is he bitching about not getting? Why is he bitching about them sending stuff to him via email if he was participating electronically? That was one of the bitches that he made. One of the gripes that he made in his motion for protective order. Plaintiff's allegations were specific. No, they absolutely were not. Plaintiff didn't just allege stereotyped and conclusory statements, but enumerated the harms to include annoyance, embarrassment, and specify the request, even using the word specifically and then attach documentary evidence. So saying annoyance isn't specific. It sounds specific, but it isn't specific. You have to say specifically what they did that annoyed you, or that would be for annoyance, I should say. What specifically they did that would be embarrassment, and probably why it would be embarrassment. Just getting a discovery response from someone, they're asking for my tax return information. Well, yeah, I mean, that's pretty standard in a lawsuit, especially one that is alleging loss of income. That's not an annoyance, an embarrassment, or anything like that. That's standard operating procedure. Just because you specifically are annoyed by it doesn't mean that you get a protective order. And again, you didn't show the non-withdrawn discovery that you claim is an annoyance. Seeking a protective order for the discovery that has been withdrawn is wasteful. The court isn't going to give you a protective order for a discovery request that has been withdrawn because it's moot. That there's no discovery request there. So he'd have to show the still active and pending discovery requests that he didn't show or allude to that we haven't seen yet. So it's not specific. Further, Rule 26C's good cause standard is meant to be a low hurdle, and the movement need only make a baseline showing of good cause in order to justify a protective order on that discovery materials be used only aid in litigation and resolution of the case at hand. I don't think that is a low bar anywhere, but this is not a case that the court is going to let you cite like this. This looks like a document. It's a Lexis citation. There you go. So he could have quoted Fisher versus Perrin. All right, but let's see where he. Whoops. I'm showing this tab instead. I found it at 6-7. At 6-7. What is a 6-7? One 13292, and this is 13292, right? So this may be revised anytime before the entry of judgment. That's phenomenal. In Ferrara versus Detroit Free Press, court held that recording by a participant to a conversation is not excluded from the definition of eavesdropping. Ferrara is not a binding authority. Oh, there must be a different one. There must be a 2023 one. I don't know. April 10th of 2023. It's 2021. Twenty 2020. I'm not seeing it. Oh, here we go. Aha! Scroll down, dude. Scroll down. All right, at 6-7 is what we're looking for. It's about a preliminary injunction standards. This doesn't look right. ATF Michigan. It's about a motion for a preliminary injunction. But this is a temporary restraining order preliminary injunction. I don't know. I don't know what we're talking about. I'm gonna pass on this. I'm just gonna say that this is probably not a citation that's going to move the court at all. Because nothing I saw was a discovery protective order. There's a difference between a preliminary injunction or a temporary restraining order as opposed to a protective order. Finally, defendant's opposition to a protective order against third-party sharing of disclosure materials shows their intent to share materials without an order. Did he ask for a protective order against third-party sharing of disclosure materials? I don't remember that. I don't know why they would share it. Normally you don't share things like that. Although plaintiff was unaware of the Honorable Judge Barrett's standing order, plaintiff did attempt to resolve the issues in extrajudicial means. Plaintiff apologizes, whereas defendants have not acknowledged their deliberate and out-of-order conduct. Defendants' objections to the standing order itself have become moot because defendants did not request a meeting with the courtroom deputy, but rather allege in their opposition their firm stance that now comes to a request for protective order. The defendants weren't the moving party. The defendants didn't have to request a meeting. They couldn't have requested a meeting. They did not know that plaintiff was going to file a motion for protective order until plaintiff filed the motion for protective order. They would have assumed that he would comply with the local rules and the standing order, and trying to shift the blame onto them. I mean, if the court isn't going to throw out their opposition to his protective order because they didn't request a meeting with the court's courtroom deputy, the court would throw out the request for the motion, the protective order motion. It's stupid. C, plaintiff did not allege that the discovery request from defendant was an issue, only the timing of them. And then conclusion. Yeah, so I don't know what he's going to do with that. The court might again make an order saying that Chile doesn't have to respond. Well, the court might just deny the motion outright because Chile didn't comply with the local rules, but he is pro se. So my guess is the court's going to fashion some sort of an order saying that Chile doesn't have to respond until 30 days after the 26F meeting or something like that, or that he has an additional 30 days or whatever to respond. That's my guess on how it's going to go. Now we have his reply to Lawrence County. Points and authorities. Plaintiff's allegations were specific. Again, he did not state the specific pending discovery requests that were not withdrawn that he has an issue with. His request for so this is the one where they withdrew their discovery request. Mootness is measured by the court's ability to grant relief, not that a specific fact has changed. Yes, so issuing a protective order saying that plaintiff doesn't have to respond to discovery requests from defendant, the defendant has already withdrawn, is a moot. It's moot. In McPherson, pending motions were moot because the dispute in the actions claims itself had become moot. Even if it did apply, McPherson speaks in detail about the capable of repetition exception, which would clearly apply here. So a claim in a complaint. So, for example, the classic example is access to abortion or whatever. Just roll with me here. Gal gets pregnant. She finds out she's pregnant after a month. She misses her period. She's been pregnant for a month, right? 8 months to go. She goes and finds an attorney. She hires the attorney. The attorney drafts a lawsuit, serves the lawsuit. That's maybe taken another month. So 7 months to go. The defendant has a month to respond to the lawsuit. 6 months to go. They start discovery. Discovery takes 6 months. Baby's born. Defendant says, problem solved. She can't get an abortion now. It's moot. That's when you would go on something like where it's capable of repetition, where it's moot now, but it's capable of repetition. So the court is going to hear the issue to see if they need to step in on that action. That's the classic example of it. It's not this. It's not a discovery dispute, dude. Of course, every discovery dispute is capable of repetition, but the court isn't going to make proactive orders about discovery that's not pending. It's not going to do it. Plaintiff's request for a protective order prohibiting premature discovery is clearly not moot in the 26F meeting still has not occurred and federal rules have not changed. Well, but again, the obvious solution would be for the court to order a 26F meeting and boom. FRCP or issue an order saying the 26F meeting is going to be held on Friday. No discovery is going to be issued until Friday. And then after the 26F meeting on Friday, any currently pending discovery is going to be due 30 days from Friday. Easily solved without having to issue a protective order. FRCP 26D1 did not prohibit defendants' action in the past and is unlikely in the future. It especially consider defendants' opposition to a protective order merely prohibiting premature discovery. But it's not. It's not. It's a protective order. It would stop them. It would prevent them from asking those questions. It's a protective order. Now, it could be fashioned in such a way that it would just give plaintiff until 30 days after the 26F meeting to respond, but that's not what Chili's asking for. And if that is what Chili's asking for, then he's asking it more clearly, more specifically. Plaintiffs did not attempt to resolve the issues. Although plaintiff was unaware of the Honorable Judge Barrett's standing order, plaintiff did attempt to resolve the issues through extrajudicial means. We've read that. Discovery requests were meant to cause annoyance and embarrassment. Defendants admit to either not reading the complaint or not engaging in discovery strictly and carefully circumscribed to the needs of the particular case. With the one huge exception of the Social Security number of anyone who helped Chili in preparing his answers. I don't think so. I mean, of the discovery requests that I read, they were trying to find out what Chili's actual contentions were, and that's specifically what they're made for. All righty, whitey. Let's see if we're going to. I don't know how long we're going to go. I got the neighbor boy up front weeding, and so there's a lot of noise. I don't know how long I'm going to be on here. All right, so we've got the ever so welcome WTT, my favorite person on the internet. We have Alpha Fox Adam. Good morning. Looks tropical there. It's fairly green. We're still in late spring, early summer. Missed you. Happy Saturday. Merb, have you been working out? I've been doing 12-ounce curls, baby. Oh, goody, it's Merb. Oh, goody, it's Pants. Good evening to you, sir. Hey, bright and early. Thanks. You're welcome. Saturday morning coffee and Merb time. Well, that will probably make you poop. Talking to chickens. Well, someone's got to. Try raw, unfiltered local honey for allergies. I've done that. I've got a lot of flowers, which you probably can't see right now, but there's a lot of flowers. I got bees flying around. I mean, good stuff. Merb's cock is really going at it today. Cock-a-doodle-doo. I'm starting to think Chili clearly can't read. Yeah, been waiting for this video. Awesome. Breathlessly. Wow, I've been looking forward to Merb's readings. Yep, I'm somehow entertainment. Somehow entertaining. Clear as mud. Awesome. Oh, Chili explains it in paragraph C. Okay. But what Chili read to us from paragraph C in his video is different than what he filed to the court for some reason. A bit too early for my usual scotch. You're just not trying hard enough. Morning, Wood Merb. How are the cocks this morning? You'd have to kiss me to find out. Does Merb lie, little Jose? I don't know what that means. Anytime Merb is live, I start drinking heavily. It's a reflex. Nice. 34th Street. It's awkward pauses when Merb reads these filings and internally questions his life choices reading this nonsense is perfect. Yeah. I mean, some of this shit just like, what the fuck are you thinking, dude? Are you thinking? Chili is using his filings for clicks and views. He will boast on his channel about what he filed and make up stupid claims, and fools donate to him thinking he has a case because they believe his crap. Maybe. Who keeps deleting comments? I don't know. I am deleting the comments. I don't have any mods, so I'm ghosting. I deleted my own comment due to misspelling. Why? I have not seen anything rude, cried, or critical. Are you are you a 1A frauditor? I am. I have done First Amendment audits. I have a playlist of my First Amendment audits, and I support First Amendment auditing. I know some of you are going to be like, "Oh my god," but no, and I'm anti-government too, and I support the rights of people to hold anti-government views and to hold extremist views and really any views. I super chat Chili $1 so I get a piece of that sweet, sweet $5 million settlement. Wow, good on you. None of Chili's video library is copyright protected. He hasn't filed any copyright on any of his videos because he can't. YouTube has the rights to the content, and he agreed when opening his account. Well, Cheeky Monkey, you spoke too soon, sir, because apparently YouTube is of the belief that Chili has copyrighted at least one of his videos. Burb, did you happen to see Chili's rant about U.S. Marshals not following a non-existent law? I've heard about it. There was a House bill or something that he thought was law, and it's not. It's not law. Wait, Viacom didn't agree to YouTube's terms of service by existing? Crazy, I know. Will you be discussing his HR 7711 video? I don't actually watch his videos, so no. HR 7711 was hilarious when he fails to understand it was never passed into law. That's what I hear. I'm complying with HR 7711 and wearing a name tag at all times now. Good. Chili is in love with Alexandria Ocasio-Cortez. It's clear to all of us. Don't kink shame his love. She's got really big ideas that, I mean, they're lovely ideas. They're great ideas. Damn, I finally found you. It's not like I've been hiding. Insert a corporations are people joke. Corporations are creations of the state. They are not natural people. They are fictitious people. They have some of the legal rights people have, but not all. AOC is cute and as dumb as Chili. She did not get into office based on her intellect. That is true. AOC is no longer the hottest member of Congress. Oh, really? Imagine the idiocracy level stupid. Imagine the idiocracy level stupid spawn. Okay. Chili is going to sue every laptop, phone, tablet, etc. that ever played any of his goofy videos. You can't sue a piece of equipment. Lowell, love your sense of humor. Sup, guys? I do it all for you, Script Cat. Naven, he's going to get my MAC address first. I have had several people on YouTube threaten to hack my computer. I wish them good luck. I don't own one. I guess Chat GPT screwed up its quote. Lol. I am really tired of this Chat GPT stupidity. It's dumb. These are not Chat GPT written. They're not. Wait, a language model AI only has a superficial understanding of the linguistic connection between subjects. I know, shocker, right? Hey, Pants, I, for one, welcome our new AI overlords. I don't think it's Chat GPT. I think it's Chili. I don't think Chat GPT would make some of the mistakes Chili makes, perfectly honest with you. I think it's Chili. I think it's help from, I think he does a lot of his research on delete laws, probably gives him a copy of a license to LexisNexis or something. Chili doesn't use Chat GPT, uses Chat, GHB. Chili gets something else wrong. I'm shocked. I know. I guarantee that Chili watches Merb read this and just thinks Merb is an idiot for not agreeing. Well, probably, but he's entitled to that. Chili is a laughing stock, a pitiful one, but fun to laugh at. So what are we here for? It's Chili. Need we say more? I hope you're here for a little bit of legal understanding. It's easy to say Chili's going to lose. What I'm here for is to tell you why. Governor Decastro is far too busy to watch YouTube videos. He's too busy trying to save black people, I guess. I hear from time to time about how Chili is going to save black people and tell them how they're wrong and how they're victims and everything like that. He wants to speak for them so bad. He wants to be king of the black people. But Chili wanted to move to California anyway. Lol, guy's a muppet. He wanted to move it to, I think he wanted Southern District. I think he wanted Central District of California, but he moved for Southern District. Not Northern District. Northern District would be a drive for him. I don't think he wants that. How much do you think Chili is out of pocket so far, looking like a moron? Well, he pays the filing fee every time. He's not going informal paperas. It's like $400 a pop. So he's got 3 pending federal lawsuits. That's $1,200. Haha. You expect him to read and comprehend? Well, I'd prefer it if he did. I don't expect him to. Not one time all his money comes from other people. This Muppet will never actually run for governor. I can't wait until YouTube boots him off the platform. See, people say this, but they don't actually want it. I'm sure that fair user watches Chili videos and enjoys the content. He's the J.R. Ewing, the guy you love to hate, and you watch his content and you enjoy him. So why would you want him kicked off the platform? It's stupid. Like, it's like you want to slaughter your own milk cow, and then you're going to bitch and moan about not having any milk. People are dumb and short-sighted. Poor Chili. I really think he will launch a campaign. Politics is the ultimate grift. Yes, all politicians are evil and bad and terrible. I'm really starting to feel sorry for him. It's like a puppy trying to sue his owner for not feeding him when he wants to. Yeah, good point. Chili plus politics is the singularity in grifting. Words are hard, huh, Chili? But jabbing at the judge is a winning strategy, isn't it? It is the best strategy for winning for the other side. The sad thing is, if Chili had finished his education and attended law school, he'd be the perfect politician. Is Jose Merb that's who jabbed the judge? Thank you. Thank you for educating me. I hope Chili does run for governor. I have some of his best videos downloaded and unedited. I will send them to his opponent. My cat chooses violence when not fed on her schedule, aka every 2 hours. It wouldn't matter where it was filed. Judges can easily spot a moron. That's not their job. Their job is not to spot a moron. The judge's job is to determine the law, and maybe, if it's a bench trial or if it's a motion hearing, to determine the facts. Chili reads like he speaks too fast. He obviously has ADHD. Well, hopefully he's getting treatment for that then. You got that right, sweet tits pants. I love when Chili are wrong. He hates Judge Burroughs. Chili Jesse Raphael is something else. Love. Obviously retarded. If Chili didn't talk so much, we would never know how little he knows. Did Merb adopt Chili? I'm so here for this. Ha ha ha. Chili is irrelevant. Why do you waste your time following that fool? I don't follow him. I'm not subscribed to him. I read filings in cases that I'm interested in. Hey, Merb, another Chili debacle. A meeting of the minds. That rules Chili out. Ha ha ha. Ha ha ha. I know Merb does not care about such trivial things, but hit the thumbs up. It kills Chili when more people watch Merb than him. I see Chili watching his and crushing all of us with his bulletproof nope defense. Yeah. Ha 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 ha. But he didn't know ahead of time that he would have to sue YouTube. That's YouTube's fault. Yeah. He's utterly a nut. Oh my fucking God. Judges are good at spotting a retard. They see him crystal clear. Again, that's not their job. Definitely laughing. What a shit show he is. How dare they contest my lawsuit? Do they know who I am, Logic? It's their fault I had to sue them. Duh, I know. Crazy. Do you get worked up because a pro se is butchering things you do in your profession, or is it just because he's an idiot, dunce, cap, and moron? It's, it's like a mechanic seeing a strip nut or a strip bolt. It's like, you're like, why? How are you this stupid? And, I've stripped bolts before, cross-threaded nuts. And so, I'm not a great mechanic, so I understand that, my viewing of Chili's work is done as a professional viewing a layman. I understand that. And maybe I'm a little harsh, but he's playing in a field where he's up against professionals. He's up against people who are my level or better. And if I'm like, holy shit, this is fucking retarded, then he's just wasting everybody's time. Cock enough for two. But Chili has threatened the judge, so it's of course going to go his way. Duh. He clearly knows nothing about the law. YouTube will delete all his channels and ban him, just like they've done to many retards. Then the fun is over. I think you're advocating for that I think you're being silly. I don't think you want that. I think you don't want to get rid of your lol cow. I mean, he probably makes you feel better about yourself. Well, after all, Chili is a 20-year law scholar. Hi, everyone. Of course. Although I know the copyright was claimed on one video after the event, surely it would never have been a factor if he uploaded to YouTube system. Surely the TOS applies even if he holds copyright. Yes, the TOS. There's a licensing provision in the TOS. Chili's so intelligent that Merb simply can't grasp the greatness. Yes, exactly, 100%. It seems to be a word soup from Chili again. Merb, realistically, little Chili, so I know which of the little suits gets fully dismissed first. Well, if I had to bet, I would bet that the Ohio lawsuit gets dismissed first because there are two pending motions. One for a motion to dismiss a 12B6 for one group of defendants and a motion for summary judgment for the other group of defendants. And that has been pending now for months. So I would guess that that's the one that's going to get dismissed first. But who knows? Burroughs could get off her ass. I am absolutely shocked that Wish and Josh Abrams' lawyer, Garrick, that Wish and Garrick haven't joined Google's motion to dismiss. What, you guys asleep? Like, what are you doing? Have your retainers not been paid? Like, why aren't you on this? I'd get on it like ugly on an 8. Governor Decastro is an expert on copy wrong law. And even though the version Chili filed with the court implies he never uploaded it to YouTube, the draft copy Chili read to us on video on his channel says that he did for safe storage. Merb signed a non-compete covenant with Law Talk with Mike. Did I? I don't recall that. I believe Chili makes everyone's head hurt. Right. NA. I'm not sure an unpublished upload is any different. It's on their servers with their TOS. Yes, it is. Nothing Chili ever says is hardly applicable to anything he talks about. Law Talk with Mike, Goat, Merb, Cock. Merb, what was your law school class standing? I was in the middle of the pack. To be fair, to be honest with you, I did not apply myself in law school. I did not. I cracked the bindings on my books, like most of my classes, the bindings of the books, I hadn't even opened them until the day before the final, in which case I would open up the book and cram. I've always been blessed to be able to learn that way, but I had very little retention. So I know this is a bit off tangent. So I graduated somewhere around the middle of my class. I think I had a B or B minus average, somewhere in there. And I quickly forgot most of what I learned in law school. And I didn't take the bar because I remember I hadn't done any studying for the bar. I woke up on the day of the bar exam. I didn't even know where the bar exam was being held. I was like, I'm not going to be a lawyer. I didn't want to be a lawyer. It wasn't in my, I wasn't feeling it. I was working I was working at a trucking company, and they wanted to make me a supervisor. And I'm like, F it. I'll just be a supervisor. And it wasn't until years later when I started getting into First Amendment auditing stuff and watching First Amendment auditors and had my own experience with law enforcement that was distasteful. I wasn't arrested or anything like that, but I didn't like the way I was treated. That I started getting into the First Amendment stuff and started reading it. And I saw there was a bunch of idiots in the comment section. And then one day I was like, you know what? I want to be an attorney. And I signed up for the bar. It was in 2016. I decided I wanted to be an attorney. I signed up for the February 2017 bar. I signed up for the Kaplan Bar Review, which was an amazing program. If you are a law student, I strongly recommend. Not paid or anything like that. Well, I paid out the ass for it. But I signed up for their bar review course, and I fell in love with it. I didn't take any time off from it. I did every single multiple choice question they had for the MBE. I took way more of the essays than I had to that they recommended. I did so many essays. One thing I did though is I realized that the essays they had were old California essays. I didn't like the way they graded my essays, because once I figured out that these were old California essays, I would look at what the California would publish the essay
for the previous year and 2 of the best responses to that essay. And I would compare mine to theirs. And I felt like I was doing much better than what the grader would grade me as. But I did all of their essays, and I did more of the California practice exams. The California gives you a set of facts and law, and they give you like an assignment, like as if you were an associate attorney at a law firm, and you have to apply the facts and the law that they give you in a fictitious state to determine how good you are at actually reading and understanding the law and then applying the law to the facts, as opposed to a rote understanding of what the actual law is. And I studied my ass off for that, and I loved it. I lived it, I breathed it, and I missed it when it was done. And then I took the bar exam, and I walked out of every single session. It was the last 3-day bar exam for California. I walked out of every single session 45 minutes at least early. I thought I was going to fail it. I passed, and here we are today. So that was my law school class standing, mediocre. The only time I've ever studied was for the Kaplan bar exam. That's the only time I've ever studied, and I studied my ass off, and I loved the hell out of it. It was a great experience. Top of the class, stays no doubt. No, I was not. I did not apply myself really in law school. Exactly, that's my point. Anything you upload to YouTube automatically grants him license. Yes. TOS, yes. Joe's having trouble with his TPS reports. I'm going to need you to come in this weekend. I believe Merb's standing was upright. Not always. Of course, he was homeschooled. I actually worked nights throughout law school. So I never studied. I never studied. Decastro and his associates, he's so dumb. Merb was schooled by Professor Rex Fredrickson. No, I was not. Cherry picking evidence from cases, cherry picking citations, I guess, from cases. This is called dicta. It sounds like a flurf. Maybe Jose is one. We know he's a soft sit. Okay. Merb, before you went live, did you run this by Felipe? No. Dude, Merb, you can't copyright a bull, silly. Okay. If you're having trouble understanding, if you're having trouble understanding Governor DeCastro's thinking, snort some Adderall and everything will be clear. Probably. It could fix everything if Chile amended everything starting at "Get Away From Me, Lady" and kindergarten. Allegedly. That was a flat derp quote, I believe. How not to law 101 by Chile. Chilita. Wait till his fit when they delete his channels. Dude, like, I don't like you. I don't like you. Myrtle Beach has passed an ordinance banning dogs on the beach from 9 a.m. to 5 p.m. from Memorial Day to Labor Day. But according to Sean Paul Reyes, if I strapped a GoPro on her, we're good to go. No, probably not. How not to law 69. Nice. How can a person publicly announce that lawsuit's purpose is to make the respondent go broke and still be allowed to proceed? Because the court is waiting on a valid motion to dismiss. Chile isn't a person. He's a constitutional law scholar, so that's a difference. I thought he was done and went off on YouTube, off in the YouTube sunset, but I guess I was wrong. Well, if you're not sub to him, probably. When is Chile going to compete with Black Laws and publish Chile's Law Volume 1? Well, Black's Law is a dictionary, not a compendium of law. It is a dictionary. Don't worry, he's promised to use writing a book. He's promised to use writing a book as soon as he finished Transparency at Constitutional Board Game, teaches constitutional law scholar, and kicks the shit out of Chad Gu. Yeah. Lil AJ, you probably just gave him that idea. Say patent pending in TM so you get a copy of his profits. Don't worry, the fasting class he's going to teach. One video doesn't protect squat. Okay, I'm officially too stoned for this. I'm going to dip my toes in the ocean. Good on you. How's the campaign to stop Terry stops? Boy video. Going nowhere as per usual. How to fast and still gain weight. He's talking about the Hammer Boy video as a key video. Well, I'm going to wrap it up here. Thank you for watching and have a great day. How's it going, bros?